Next, we'll talk about contract law. What is a contract? A contract is a mutual agreement between two or more parties. A contract may be written or verbal, and a contract may be formal or informal. You deal with contracts in a number of different situations, including employment, construction, security, inventory management, concessions, insurance, leases, programs, and franchises. There are several different elements to a contract. The offer has the intent of the contract with some legal content. Basically, this offer is unilateral until it becomes accepted. Both parties have to be competent and have the capacity to agree to the contract. Once there is agreement, the contract becomes bilateral. Within a contract, you need to have what is called consideration, which is the benefit to each party, what each party is receiving out of the contract. The legal content of the contract offer must have objectives and intent. What are the objectives of the offer, and what is the intent of offering the contract? It must be presented by and to someone with capacity. Basically, that means somebody who is in age of majority, 18 years or older in most cases, not insane or intoxicated, and not a convict during their time of sentence. Otherwise, if you make a contract to or by one of these people, they're beyond their capacity and not able to enter into a contract. So here are some issues to consider, good questions to think about as you're thinking about your recreation business. Is an advertisement actually an offer, a unilateral contract? That's a good question. How about this? Is location and the presence of a business a unilateral contract? And for both of these, how can these offers be terminated? These are things you might want to consider as you begin planning your recreation business. There are four main ways to terminate an offer. Revocation refers to pulling an offer before it is accepted. Expiration refers to having a date and time at which, if the offer is not accepted, the offer is terminated. There's also a reasonable time, which is an implied term. If the offer is not accepted within a reasonable time, which may be specific to the contract, then the offer is terminated. And finally, if you offer a contract and the other party rejects the contract, as long as you do not offer a counter offer, that contract is terminated. So what is an agreement? Basically, an agreement makes a unilateral offer become a bilateral contract. It's where consideration is returned to the agent or the person making the offer. So consideration is acceptance of an offer. And there's basically three ways to do this. You can have expressed acceptance, where there's written or verbal agreement to the agreement. There's implied acceptance, which is a return promise. And there's a forbearance, which is a conditional acceptance. So why are written contracts so important? First of all, written contracts may vary state by state. Different states will have definitions of what types of contracts and agreements must be in writing and what types of contracts and agreements may be verbal. It's important to know that the Uniform Commercial Code may have rules and laws that apply to interstate commerce. It's important to do your research and do a little investigation and know when written and verbal agreements and contracts may be appropriate for your business practice.